Welcome back, folks, to Keepers of Liberty. In this section, I'm excited to dive into a key part of the Constitution, in particular, a key power that under Article 1 of the Constitution, we the people delegate to the Congress. We're going to talk today about the Commerce Clause. What is the Commerce Clause? Well, it's one of the most debated provisions in our nation's history. It affects everything from trade and business regulations to the balance of state and federal power. Today, we're going to break it down. What it says, what the founders intended, what it really means, and how the courts, for better or worse, have interpreted the clause over time. So what is the Commerce Clause? Let's start at the source. And every time you begin with a constitutional analysis, the place that you need to start is the Constitution. So let's look at the source. The Commerce Clause is found in Article 1, Section 8, Clause 3 of the U.S. Constitution, and it says that the Congress shall have the power to regulate commerce with foreign nations and among the several states and Indian tribes. So Congress shall have the power to regulate commerce among the states. In simple terms, this clause gives Congress, we the people delegating to Congress in Article 1, the power, the authority to regulate trade that crosses state lines, and as well as international trade and commerce with the Native American tribes. But what does commerce actually mean? That's a question that arises from time to time. And how much power does the federal government, does Congress really have under this clause? That's where the debate begins. And why did the founders even include this clause? Why did we, the people, delegate this power to the federal government? Well, to understand the Commerce Clause, we need to go back to the Articles of Confederation, which came before our Constitution. The federal government under the Articles of Confederation was weak, and states were, putting up trade barriers with each other, taxing each other's goods, and making economic cooperation just nearly impossible. And the founders knew that for a nation to be strong and prosperous, that this had to change. James Madison wrote Federalist 42 in support of the ratification of the Constitution. And he was talking about the proposed provision here called the Commerce Clause. And James Madison saw the need for a national authority to regulate trade so that we could, at a national level, prevent economic chaos because the states just had too much different interest with each other. And so let's all, as one nation, put that authority in the federal government. Alexander Hamilton, in Federalist number 17, reassured that federal power would be a help to the national unity and wouldn't interfere with state sovereignty. The goal was clear: eliminate trade barriers, ensure a stable economy, and promote unity among the states, not to get rid of state sovereignty. So, very clear what the words meant at the time they were written. Some early Supreme Court interpretations. One of the very first major Supreme Court cases to interpret the Commerce Clause was Gibbons versus Ogden. And that's a really interesting case. Two steamboat operators were fighting over a monopoly granted by the state of New York. One had a state license and the other had a federal license. The Supreme Court, led by Chief Justice John Marshall at the time, ruled that Congress has the exclusive power to regulate interstate commerce under the Commerce Clause power. What's the impact of this decision? The ruling confirmed that states could not interfere with Congress's ability to regulate trade between the states under the commerce power in Article 1. But the court also set limits. Congress could not regulate commerce that was purely local. Why? Because the Commerce Clause says that Congress has the power to regulate commerce among the several states, not purely local commerce. Well, what happens though when courts start to take a different approach to interpreting the Constitution. Say, we now know what it means, but what if we don't like what it means? What if we want to regulate local commerce? Well, let's just, maybe as a judge, because I'm wearing a robe, can I change the meaning of the Constitution? And when courts interpret the Commerce Clause today, they're often following one of two approaches. One is, originalism that says, no, we're going to hold to the view that the words have meaning and we know what those words mean, and interstate commerce means interstate commerce among the several states. It doesn't mean local commerce. Those meanings are fixed. They shouldn't change just because some judge wearing a robe want to give the federal government even more power to regulate individual citizens. And so that's the other approach, this living constitution approach we've talked about earlier. And that approach argues that, the Constitution's meaning can evolve, remember, over time, allowing judges to adopt it to whatever the personal preference of, the particular judge may want. What is the political preference that judge may want? Well, look what happens. See how those two different worldviews, those two different approaches to interpreting the Constitution have resulted in very different outcomes. Once again, where you begin determines where you end when you have a constitutional interpretation issue. So let's look at originalism in action. And because originalism really limits the exercise of federal power here. There was a case in 1995, United States versus Lopez. And that case involved a federal law that banned the possession of a gun in a local school zone. Understand now, it's not a state passing a law, but the federal government passed a law that made it a crime to have a gun in a local school zone. Good law. We don't want somebody carrying a gun into the local school. But the question is whether the federal government ought to be able to make the law. Because once again, whenever you see Congress acting, the very first question you need to ask the Congress is, where did you get the constitutional authority to make that law? What power source did you plug into when you exercised power, making it a law that only covered a local school zone? And you are relying on a power source that says you're regulating commerce among the several states? Well, what happened? The court struck that law down. Not because it wasn't a good law or a good public policy, but the court struck down the law banning a gun in school zones because carrying a gun in a local school zone isn't commerce among the several states. Another case, United States versus Morrison. In that case, the court ruled that Congress couldn't use its Commerce Clause power to justify parts of the Violence Against Women's Act. Again, good law with good intent, trying to stop violence against a human being. Not a bad public policy. But where the gender-based violence in the statute didn't impact interstate commerce and once again was designed to regulate something just locally, the court struck it down, not because it was a bad public policy, but because the wrong government was writing the law. Here, Congress didn't have the power, they didn't have a power source to plug into to regulate commerce among the states when they weren't regulating commerce among the states. They were regulating purely local conduct again. Key takeaway, these cases reaffirmed that there are limits on the federal power and states are sovereign. States are sovereign and the federal government can't use its power beyond that which is authorized in the Constitution. All right, let's look now at a whole nother set of cases. There's this one case called Wickard versus Filborn. And there, you had the federal government supposedly plugging into a power source and saying it had the power to regulate a farmer who was growing wheat for his own personal use in his house. And the federal government said, well, we've got the power to regulate as a federal authority because the local farmer's action, even though he's only growing a teeny amount of wheat for his own personal use, that possibly could affect overall wheat market. Here, the court upheld the government action and talk about a use of judicial activism to put a political preference in place that is completely opposite of what the Constitution actually says. Because here the Supreme Court said, okay, federal government, it's okay, even though this really isn't commerce among the states, it's okay for you to regulate this local farmer growing wheat just for this farmer's own personal family use. Very, very dangerous, in my view, when you allow an unelected federal judge to change the meaning of the Constitution just because the judge disagrees with the policy and wants to allow the federal government to do more than the Constitution allows the federal government to do. Similar type case in a case called Gonzalez v. Raich. That's a much more recent case where the court upheld even locally grown medical marijuana, which was legal under a state law. They said that could be federally regulated under the Commerce Clause. Again, good public policy perhaps, but the question is, where did the federal government get the authority in the first place to start regulating something locally when the Commerce Clause makes it very clear that it has to be commerce among the states? So key takeaway here, these cases greatly expanded, improperly in my view, the federal power, allowing Congress to regulate even local non-commercial activities, if they could, make up in their mind some broader economic impact. What does this mean for federalism? I mean, when I say federalism, we've got the federal government and then we've got the 50 state governments, and together we are a nation. And so for federalism, there's some implications here. The balance between the federal and state power is at stake when you've got judges improperly determining what the Commerce Clause means. And that proper balance between federal and state power, works when you've got federal judges that actually say what the Commerce Clause really does mean and then applies that true meaning to whatever facts are in front of them. When you expand federal power to something that allows for more national regulation, that's going to reduce state sovereignty and state autonomy, inconsistent with what this particular provision of the Constitution allows. On the other hand, limiting federal power is going to strengthen state sovereignty, and it's going to allow a marketplace that'll be different between the states, and so you can have different states doing different things, which is okay. And you will have, therefore, a federal power that's only exercising power that the Constitution allows. So the Commerce Clause has shaped our nation's law in profound ways. Understanding how it has been looked at by different courts helps us grasp the broader struggle between federal authority and state sovereignty. I hope this has helped you understand the debate a little bit better, and you can see where we stand. We stand that, truth matters. The lens through which you see the law or the constitutional provision is important, and judges should only say what the Constitution says, what it really does mean, and then apply that provision, like the commerce power in Article 1 of the Constitution, to resolve the case in controversy in front of us. Well, thanks for joining the conversation today, and look forward to the next session as we go through the different powers of the federal Constitution.